Good afternoon and welcome to this meeting of the Licensing Subcommittee. The first item on the agenda is the election of chair. Could I please ask for nominations for chair?
I nominate Janice Howard, Councillor Janice Howard as chair, if that's all right.
Thank you, Councillor. Is that seconded?
Seconded.
Thank you very much. Over to you, Chair.
Thank you. And I'd like to welcome all parties and all present to introduce themselves. So if we can first of all ask Caroline to introduce themselves.
Thank you, Chair. My name is Caroline Sharkey. I'll be giving a brief outline of the report and the matter that you're considering today before you. I'm the licensing manager. Thank you.
And Noel?
Hello, hi, good afternoon. Noel Goddard, Operations Director at Colette.
Matthew?
Good afternoon. My name is Matthew Phipps. I'm from TLT Solicitors and I'm presenting the application on behalf of Colette this afternoon.
Okay, Ellie?
Hi, my name is Ellie Nicole Davis, here with TLT, and I'm here to observe the application.
Okay. Tom?
My name is Ellen Williams. As it happens, I live at 77A High Street, i.e. above the shop in question. I also happen, for what it's worth, to be a personal license holder, so I have some awareness of what is involved in licensing.
Councillor Draper?
Hello, I'm Councillor Nick Draper. I'm one of the committee members. Thank you very much.
Louise?
Hello, I'm Louise Miller. I live at 77A the High Street, long-term resident for 33 years in the building, and I object to the application.
Guy Bishop, legal advisor to the committee.
Councillor Dehaney?
I'm Councillor John Dehaney, one of the member of the committee.
And Amy?
Amy Dimitrescu, I'm the clerk to the committee.
Thank you. You will all have received a copy of the hearing procedures with the agenda packs which have been sent out. I'm going to ask the legal advisor to inform those present about our prior briefing and the procedure for clarification of any aspect of the application, and to further confirm the procedures for questioning and whether there have been any requests for adjournments.
The committee in Merton meets before the hearing to read the papers and to ask any basic questions about the process. Gave very general sort of understanding of what's involved. And that's it. Obviously, any deliberations, any decision is made in the actual final decision meeting.
Can I ask the licensing officer if there are any technical issues that they feel should be brought to our attention?
There's no technical issues, Chair, but I was going to give you an outline of the application, if I may. Right. So this is just to give you a brief outline of the application, Chair. This is an application submitted by Colette Wimbledon Limited for a new premises license known as Colette at number 77 High Street, Wimbledon. The premises are not located in a cumulative impact area. The description that has been given by the applicant is that the premises proposes to specialize in a takeaway food in the form of fully plated meals, and will also incorporate a shop akin to a high-end delicatessen. And the premises will have a small number of seats, allowing for consumption within the premises, and alcohol will feature as part of the range, and it will be supplied to be consumed on and off the premises. The application is again for the both of the sale of alcohol for both consumption on and off the premises between the hours of 8 a.m. and 10 p.m., 7 days a week. The opening hours are stated in the application from 8 a.m. to 10:30 p.m., 7 days a week. The applicant chair has offered some conditions in section M part of the application to promote the licensing objectives. If the subcommittee is minded to grant the application, these can be formed as conditions of the license. The subcommittee may modify these conditions if they consider steps appropriate after hearing all the evidence today. The applicant advertised the application, chair, and as required under the Licensing Act, this has resulted in the representations made, which is why we are considering this matter today. The representations that were received, chair, were in particular that of the prevention of public nuisance being undermined if this license were to be granted. The local residents have raised concerns about the potential of noise and disruption caused by groups of 16 people eating and drinking until 10:30 p.m. in the premises, and one of the residents have actually raised that they live directly up above the premises. In terms of other matters that the residents have raised in terms of planning consent, this has been explained to the objectors that this is a matter for planning and it's not for the Licensing Act. We've also informed the residents that the premises are not actually situated in a cumulative impact zone area, because this was changed with a new latest licensing policy which came into effect on the 6th of January this year. The applicant, through negotiation, has agreed some conditions with the Police and Parkside Residents Association, and these are all deliveries of alcohol to the premises had to be made to the premises or residential address and not to any public spaces. No alcohol sales for consumption on the premises before 10 a.m. Any alcohol sold for consumption on the premises to be sold as an ancillary to a meal or as part of a pre-booked event, with all attendees' details being available to officers upon request. No more than 16 customers will be permitted at any one time to consume alcohol within the premises. Due to these conditions that have been offered up by the applicant, chair, it's amended the starting time slightly from 8 a.m. to 10 a.m. The applicant has also been in communication with the Environmental Health Authority, and they've actually clarified the application further. They've actually stated that off sales will be predominant. The permission of on sales is only yet to be returned for wine tasting, and it will be all more limited. The applicant has also clarified the application that there will be no furniture for seating, no tables and chairs inside, no access to the toilets for customers, no tables and chairs outside. Absent sitting, the customer will also the customers will be standing. So this has changed significantly the description that was given at the beginning of the application, for the committee to consider that today. All the copies of the representations that we received, chair, have been forwarded to the applicant and the committee for consideration. So the committee today will have the following options to make in considering this matter to promote the licensing objectives. The committee can grant the application in its entirety as applied for. The committee can modify the conditions proposed by the applicant. The committee can reject the application, and that's the application as I understand it, chair, unless there's any points of clarification. Can answer. Thank you.
Thank you. Can I now ask the applicant to present their case? Questions can then be asked of the applicant by responsible authorities, interested parties, and members of the subcommittee. Thank you.
Chair, I'll present the application this afternoon, please. So as your licensing officer has set out, and a number of the points candidly I'm about to make will repeat some of the points she's made. It's an application made by Colette, Wimbledon Limited. In attendance is Noel Goddard, the operations director for the Colette business. The proposed location is 77 High Street, and effectively this is an application for the second Colette. the first of which is on Fulham Road and has been there for about 18 months. In terms of your agenda, please, perhaps counterintuitively, the place to start, if I may, is on page 32 of the paginated numbers, but in the link that I was sent by Amy, it's page 41 of 63 in the top left-hand corner, if your screen is the same as mine. Obviously, I don't know, but it's paginated at the bottom of the page. I can see, yeah, Councillor Draper's got paper copy, of which I'm envious, candidly. But page 32 for the paginated. And what this is, Madam Chair, is an email effectively sent through to the licensing service in January in order to introduce the proposals to the responsible authorities. I'll canter through this. I take from Mr. Bishop that you've had the opportunity to meet in advance and to look through the papers. So with your permission, I'll just canter through it. It is proposed that there is a takeaway shop and delicatessen, and we'll come to the presenter in due course. It references a small number of seats, but it's right, as your licensing officers highlighted, the seats element will fall away, and I'll come to that in due course. On and off sales are the licensable activities being requested. There is a website address provided. I don't know if you've had the opportunity to look at that, but I would invite your attention to that and to follow through on that link, please. Obviously, that primarily references the Fulham Road site at present, but it's instructive for what the business is like and what you might reasonably expect to see if you're minded to grant these premises a license. Moving through, effectively, it's a delicatessen providing ambient goods, that's tinned, jarred, and so forth, which would include wine, predominantly beer, and some, I believe, limited spirits. But the predominant nature of the business is what we would call high-end, and you will have seen in the Colette link that the history of the business and its inspiration from Belgium is a Michelin-starred background, fully plated, what I would respectfully call proper takeaway, eat-at-home food. 3-course meals at that. And perhaps unsurprisingly, bearing in mind the 12 months that we've all had to endure, the business has thrived and wishes to expand its operations in Wimbledon. The proposed hours are set out. We'll come back to the application. As your licensing officer has quite rightly said, in respect of the on-consumption of alcohol, that is proposed to be limited to 10 a.m., not 8 a.m. as first applied for, and that arises from the discussion we had with Parkside and Belvedere residents. There's an operating schedule that I will return to, but we say a comprehensive one that fairly attends to the individual merits of this application. There was an offer to meet remotely and a request that this was passed to officers. We then engaged in some dialogue, as you will have seen. Below that, for me scrolling, but for hard copies sort of moving through the pages, on to page 34, paginated, page 43 of 63 in the online version, is a presenter disclosing photographs of the existing Colette unit and a fair representation of what you will, if you're minded to grant a license, see in Wimbledon. Just scrolling through that, the third page, 45 of 63, a little bit about the background with some examples of the food. Then on to 46 or page 37, reference to the Michelin-starred restaurant group La Villa Lorraine. Then a little introduction to Fulham Road, some before and after photographs. a unashamedly marketing page highlighting some celebrity endorsements and customers, then introduction to other businesses and suppliers with whom we have relationships, then a page on the team, and you will see Noel Goddard, the operations director, on that page, as well as Chris Hill, the executive chef, formerly sous chef at the Ritz, an advisory board, and then some press articles that you may have had the opportunity to explore, but which effectively confirm, I hope it's fair to say, that the high-end takeaway offer and delicatessen is what has been such a success in Fulham. Then a little on to Wimbledon Village, and the one point, perhaps slightly quirky point and not necessarily pertinent to a premises license application, but on the left-hand side, a high dog population perceived to be the market in Wimbledon, who may be interested in our dog food offer, which will follow in due course. And then some contact details and a photograph outside the existing premises, and then a photograph of the existing premises, less the staff. So hopefully that's just a helpful window into the application. Then as we scroll down to page 56 of 63, which is 47 on the hard copy, you effectively see confirmation of the dialogue and exchange with the police, who requested that the operating schedule attached a specific condition relating to deliveries of alcohol only being permitted to business or residential addresses. And as your licensing officer quite rightly said, when you come to consider this application, the applicants and the police would be inviting you to attach that condition to the license, please. We then scroll down to page 59 of 63, or page 50 on the paginated version. And there is the exchange with the Parkside Residents Association, who I think also represent the Belvedere residents, with two conditions being proposed. The first, that no alcohol sales for consumption on the premises be permitted before 10 a.m. And if you're minded to grant the license, we'll be inviting you to attach that as a condition or to restrict the license accordingly. And secondly, that any alcohol sold will be ancillary to a meal or as part of a pre-booked event, with attendees' details being available to officers upon request, and those attendees being limited to no more than 16 persons. The genesis for that condition, and you can scroll through the emails, the email below, but in simple terms, Parkside residents wanted to make sure that the premises couldn't become a wine bar or develop itself were Colette not to remain in the premises. And if you're minded to grant, we'll be inviting you to attach that as a condition as well. If I may, I'll just ask you then to scroll up, please, or to turn up to page 37 of 63, or on paper version, page 28 of your paper version. And there you will find the operating schedule that we submitted with the application. I'm not going to take you through it line by line. I candidly hope you'll be relieved to hear that rather than disappointed, but of course happy to if you would like me to. But there are a couple of observations I would make. So food available throughout the premises, throughout the trading day. The substance of this business is a food business. Clearly, both the conditions on the license and hopefully the photographs the presenter and the existing business would confirm as much. CCTV, delivery conditions, public safety conditions, and a number then of public nuisance conditions, I think, as your licensing officer rightly advised, the primary concern about the representation which has caused the hearing is a public nuisance concern. I won't take you through those, but litter, refuse, deliveries, collections, noise, fumes, steam, odours, and that sort of thing that you would, I hope, expect to see in a comprehensive, well thought through operating schedule. And then in terms of protection of children from harm, as your policy advises, challenge 25 policy in the middle with a variety of other ancillary conditions attending to all the sorts of issues you'd expect, attending to age and delivery. We would probably, obviously, and I appreciate that it may be said, well, you would say that, wouldn't you? But we say that's a comprehensive operating schedule and can, at least in part, fairly explain the absence of any responsible authority submitting a representation to this application or having a live representation to this application. Beneath that on page 39 and on page 40 is the plan and layout of the premises. The Fulham Road premises does permit a couple of stools to be positioned within the premises and for people to sit when consuming. The view has been taken that that won't happen at Wimbledon, and therefore, as your licensing officer explained, there was the engagement with environmental health, and we clarified the position as regards furniture. Quite fairly, the point is made that therefore the original description slightly oversells the premises, and I probably have to accept that that's fairly pointed out, but candidly, it oversells it rather than undersells it. There couldn't fairly be said to be any prejudice arising from that. That does lead me back. I'm sorry I'm jumping around slightly, but if I might just invite your attention toward the operating schedule again, and forgive me, just to find the specific. In the 6th condition on the prevention of public nuisance point, which is page 38 of 63 or page 20 or page 29 on paper version. The 6th condition reads, any outside seating shall be limited to an area marked on the plan and afforded the appropriate tables and chairs permission. Effectively, Chair, that condition can either be removed, or if you're minded to leave it, perhaps tidied up by deleting area marked on the plan. I'll leave that as a matter for you, but there's no attempt to go behind the dialogue with the environmental health officer. There are no tables and chairs here, either in or out. That then leads me down, please, through the document to the representation from the objector, and that is Miss Miller, and that's set out on page 51 of 63, forgive me, 60 of 63, or page 51 in the paginated version. I did hear your licensing officer refer to residents as objectors, but actually it is a single resident. Only Ms. Miller is engaged here. Dealing with the representation, obviously she is here and she will speak to her representation rather than have me speak to it, but a couple of observations, please. Second paragraph, clear that there's no objection to the off-license part. It's recognised that that's necessary for the business. The objection is to the on-license part. And so dealing with the on-license part, we would like to engage with our customers in the premises. That's what we do in Fulham Road, and that is what we would like to do in our business as we go forward. We are not either trying to create a wine bar, nor are we trying to create a license that might allow someone else at some unspecified future date to create a wine bar. That is why we are happy to have a restriction in line with the Parkside residents' discussion that, first of all, the 10 a.m. Commencement time, but also more importantly, limited 16 people, limited to ancillary to food, which immediately prevents it from being a wine bar, or as part of a private event, effectively, where we've got details of all of the attendees and where it's limited to 16. We anticipate that we may have, for example, a wine producer come and give an evening. We may have regular customers. We may want to put on an event for an hour or two, and we don't believe the licensing objectives would be undermined by that. Of course, that's a matter for you, not a matter for me, but we say that the operation looked at in the round fairly allows for that to proceed. I appreciate that Ms. Miller doesn't agree, and you'll hear from her in due course. The planning point raised in her representation has been touched on by your licensing officer and is covered in the original officer's report, but you'll be familiar with your own policy on that. Respectfully, I don't think it's right, actually. I don't think there is any requirement for planning here. And then secondly, there's reference to the cumulative impact issue. Again, respectfully, that's wrong, of course, because your policy has been revised to take account of the fact that this is no longer a cumulative impact policy area. But I am bound to say that even if it were, looking at this application and asking yourself the single question really of import in all licensing hearings, will this create public nuisance, create crime and disorder, undermine the public safety or protection of children from harm objectives? Obviously, with this operating schedule and this offer, I'm bound to say not. Your policy, madam, I won't presume to tell you your policy, but I suspect it will be something that Mr. Bishop will be giving consideration to when he advises you on later. And so it just may help, I hope, if I just finish with a couple of quick observations about your own policy and perhaps offer up the paragraph numbers that I say Mr. Bishop may want to just bring to your attention when you retire. 4.5, which is your main principles section. If you've got it in front of you, I can give you the, I'm sure you know better than me, but 4.5, so each application on its individual merits, appropriate weight to representations, and obviously I say with no responsible authority representations, that's a significant point. And conditions focused on the operation and tailored to the operation, which we say these clearly are. 6.1 is your duplication point. 9 covers cumulative impact. 10 covers risk assessment, and I hope the operating schedule fairly discloses a fair assessment of the business and its location. 10 touches on conditions, and then 10.10 touches on conditions, and 10.11 talks about pre-application consultation, a dialogue and discussion with the responsible authorities being encouraged, and you, I hope, can see we've undertaken all of that. So I suppose the final point, Madam Chair, and thank you very much for the courtesy of letting me speak for as long as I have, is that sometimes on these things, I'm minded to suggest that solicitors overcomplicate these cases. Perhaps it's been suggested I'm minded to overcomplicate these matters from time to time. This isn't a complicated one, actually. The off-sales element doesn't appear to meet with anybody's objection or resistance. We say that the on-sale element, restricted in consultation with Parkside residents, fairly mitigates any anxiety that may fairly be articulated to you, and we would invite you to grant the application.
Thank you. I would now like to invite questions of the applicant from people here?
Chair, if it's the turn of the panel to ask questions, just one question. Caroline Sharkey mentioned that there would be no toilets available. Is that the case?
That's right, sir. Yes, that's right.
Okay, thank you very much.
And can I ask one clarification? Did I hear correctly that when these parties of 16 are having their wine tasting or eating and drinking in, there are no chairs and tables?
That's right, madam. They're not proposed to be any. It will be a relatively time limited affair, and it's not anticipated there'll be furniture.
If there are no more questions, can I ask the interested party to their presentation? Thank you.
Is this appropriate for me to speak now? I keep wondering why.
Oh, forgive me for interrupting you. I apologise, Mr. Emily Williams, but I'm not sure who you are. The representation.
I said at the outset that I live at 77A, i.e., above the premises in question.
Yes, I appreciate that, but
sorry, can I? Sorry, I'm the legal advisor to the committee. Let me step in here just quickly. Mr. Williams, the problem here is you didn't put in a representation. It was Miss Miller who put in the representation.
My apologies.
And as such, she is the person who's meant to be speaking, and not you, unless she's invited you to speak on her behalf. Perhaps Miss Miller could clarify. You're on mute.
Okay, he's my husband. We live together in the flat. I asked him to come along, obviously, because we have the same problems with the application, but also he is a personal license holder and has some knowledge of licensing. Just to say, I still cannot comprehend how you think it's acceptable to have groups of 16 people eating and drinking with no toilets, no chairs and no tables. I just think that's madness. Because we have already, I know we're not an impact zone anymore, but we have the most enormous number of licensed premises in the high street. And when the lockdown eases eventually, there'll be a lot of people already in the high street. We have terrible problems with evening parking. We have the Ivy 2 doors away from us, and we already have huge problems with lorries, delivery vans, etc. from them. I understand that the food, all the food that's for Colette is going to be prepared at Fulham and then brought by van. Presumably you will also have delivery people coming and going from your premises from 10 a.m. to 10 at night. There is no parking outside the premises because it's on a double yellow line. We're actually almost on the roundabout of Church Road and the High Street. We're on the top floor. My neighbour below on the first floor, there is absolutely no insulation, sound insulation between his floor and the ceiling of the premises in question. I would maintain that this is not the right premises for this operation. I think it's too small. I think it's in the wrong place. There are many other empty premises in the high street that would be better for this operation. And I just object to having serving alcohol in the premises. I don't think it's a workable application.
Yes, Tom?
Am I allowed to mention the fact that serving wine or drinks of any sort, when there are no provision of toilets on the premises, and as it happens, the last public toilet that we had here in Wimbledon closed about 10 years ago. And it really is a problem. It's one thing for if you go to the Dog and Fox across the road, there are public loos there. But these people are proposing to have a what amounts to a wine bar, and there's no toilet. And I just don't see how that's reasonable given the area. It would have been nice had they bothered to get in touch with those of us. The Parkside Tenants Residents Association is sort of 4 blocks away from here. The Belvedere residents are at least 1.5 blocks, if not 2 blocks away. I know quite a number of them because a number of us go to St. Mary's Church here in the village. And so I know people here, but I know that they're just, I don't think there's been proper consideration of the fact that we're, as residents of the high street, it's just overkill. I'm sorry. If this building was offices above, I'm sure there would be a lot less concern. But people actually live here above this shop. People live above the shops immediately to the right and to the left. And I don't see how it can be justified in what is, whether it's a congested area or not anymore, there is still a problem with the fact that if you're going to be serving drinks to people until 10:30 at night, and there are no toilets, I think that's an extra reason not to allow it. Thank you.
Can I ask for any further questions from those present? Does the licensing officer have any further comments or clarifications?
No, Chair. It's just to obviously remind members that we only receive 1 representation, and that needs to be taken into account in the deliberation. Thank you.
Yes, you can't go outside the representation that's been presented.
Can I ask the legal advisor for any comments or clarifications?
Apart from those that I've given, there's nothing further to add.
Are there a closing statement?
I think Councillor Draper has a question.
Oh.
I chose not to ask it. It's okay, thank you.
Oh, Councillor Dehaney.
Okay.
Muted.
Yes, Chair, just a comment. I think I have to agree with Mr. Williams. If you are selling alcohol from, say, 10 a.m. to 10:30, you should have a toilet on the premises. So you shouldn't really apply to sell alcohol without having a toilet on the premises. I'm a regular visitor to pubs, and I know, you don't have it there, you're in trouble. That's all, Chair.
I think we're straying towards planning issues rather than licensing issues on that front, but obviously we'll debate those in deliberations.
Can I ask for a closing statement from the interested parties?
Sorry, Chair, I think Ms. wanted to make.
Yes, interested parties.
No.
Can I ask for a closing statement?
Can I say something?
Yes, I just asked.
Can you hear me?
Yes.
Yes. The other point I had made in my initial objection was that it seemed to me that you were trying to change the use of the premises without going through proper planning. I still don't understand why it's acceptable to bring this application through a licensing committee and not a planning committee when you're changing the use of the premises from an unlicensed to a licensed premises.
Ms. Miller, maybe I can help you again on that one. The situation is that obviously the licensing committee deals with licensing subcommittee deals with things related to those things that licensing allows. Those things that are related to planning are matters for planning and planning enforcement. So the committee is not, when looking at a licensing application, it's only looking at whether the operation of the license and the operation of the premises will result in any problem with crime and disorder or public nuisance, etc. So it's not looking at planning issues. The applicant and the company Colette Wimbledon Limited will be aware. Sorry. Sorry, I was being interrupted. Sorry about that. The applicant will be aware that they will have to apply for planning change of use if that's what they need to do. That is a matter for them. I would say if the way they've changed their application suggests to me that they're trying to operate more as a shop than as a licensed premises that would have people in there. But that's a matter for them, and it's outside what the licensing subcommittee is looking at.
So
Can I have a share?
Yes, John?
If we grant them a license for the plaque or change of use, what is to stop them from selling alcohol on premises without, changing the premises?
Change of use is a matter for the planning committee, John.
Yeah, but
you are not considering what the planning committee will and won't do, and what the planning authority will do in terms of enforcement. You are considering only the licensing application and whether a grant of a license should be permitted. That is all.
Hello.
Can I now invite closing statements from the applicant?
Madam, thank you. Committee, thank you. Couple of observations, please. Your legal officer quite rightly said that you are limited to consider those parts of the representation that were presented, but respectfully, it's that were presented within the written representation. You cannot develop
That's what I meant.
Points. Forgive me, I appreciate Mr. Bishop. This is more for the committee than you, but you cannot develop points that were not fairly contained within and could not be said to be contained within the written representation. So I would just ask you to bear that in mind when you retire. The second point is that there's no objection by any responsible authority nor any person to the off-sales part of this application. It is right, and we recognise that it's right, that, and Mr. Bishop articulated it perfectly, that with the restrictions now in place following the dialogue with the Parkside residents, the emphasis here is much more on a shop. I'm no planning lawyer, and obviously I take the point from Mr. Bishop that this is outside, planning's outside licensing anyway, but I don't think it's our view that planning is required. It's a shop now, it'll be a shop, but having an ancillary permission to allow it some modest permission to conduct wine tastings in line with its operation does not make it a wine bar. It does not make it necessary for it to have a lavatory. Respectfully, if you look at this operation, the presenter, the operating schedule, the hours permitted, is it your view, and I would invite you to consider this when you retire, is it your view that these premises or these customers at these premises, if permitted to consume inside, are going to cause public nuisance, undermine the crime and disorder objective, undermine the public safety objective, undermine the prevention of harm. That can't be a fair conclusion. Each application has to be considered on its individual merits. What's suitable for the dog and duck may not be suitable for the Crown and Two chairman or for Colette. If I were to make a submission that says there are no lavatories in a Majestic wine warehouse and they're permitted to have wine tastings, you quite rightly would say to me, well, Mr. Phipps, we're not considering a Majestic wine warehouse application, we're considering your application. So I wouldn't make that submission. Well, respectfully, that must be a fair point for me to make as well. If fundamentally your anxiety is that there is something about the way in which we would conduct the limited on-sale proposition that ties directly into the lavatory point, then limit our use of it so that your anxiety is mitigated. I would invite you to grant the application, but moderate the permission rather than respectfully to throw the baby out with the bathwater, because there is a residual anxiety that we say unequivocally does not attach to these premises, this application or this proposition. But if I have failed to persuade you of that, then only allow us to have people consume on the premises for no more than, say, 2 hours in a day, or something like that, that would attend to, forgive me for personalising it, Councillor, but Councillor Dehaney's anxiety. Because that must be, respectfully, the better approach than simply to say, well, we refuse it. Because, and I go back to this, and on this point I'll finish, if you look through the paperwork, the proposition, the operating schedule, and the presenter, there cannot fairly be said to be anything here that can fairly and properly be said to undermine the licensing objectives. Thank you.
Tom, I see you have your hand up. Unfortunately, the time has passed for questions and the applicant has the last word in the list. And there was a previous occasion when the interested party could have responded. The subcommittee will now retire for private session. The legal officer and clerk will also be invited to retire to provide advice. All parties will receive a written copy of the decision notice within 5 working days. And so I will now close the hearing and ask everyone that is not in the closed session to leave.
Thank you. Good afternoon.
Thank you. Goodbye.